Hi, everyone, and welcome to the Estate Planning 101 Refresher. I want to welcome you today. My name is Jennifer Kleckner, and I'm the co-owner of 10X Prosperity, and I'm here today with my partner, Kurt Berry, and also Lance Evans from Legacy Life Planning. And we're really excited to be here today because we're bringing you 70 years of experience in retirement, investment, and insurance business. And we really want to be able to talk to you today about the importance of estate planning and your beneficiaries. And let's really first start with that question of why do I need to have a estate plan? And really, I want to have you just pause for a moment and really think about that question. Why should you have an estate plan? And really, a lot of things that we hear from our clients is, I want to make sure that my wishes are met after I'm gone, or I want to really be able to protect the beneficiaries that I have. I've worked so hard all my career. I want to make sure that they get exactly what I've wanted them to get. So it's really important that we have that estate planning and the program in place so we are all protected. And when we really think about it, some of the people will say, well, I only have a house, I only have one child, I don't really have a whole lot of assets. Well, if you really stop and think about it, whether you have some assets, some children, it's really, really important that you have something in place for when that time comes. And really, it is important because as we look at the stats that are in America, 67% of Americans do not have an estate planning document in place. And it's really quite scary to see that number. And if you look at the next slide, Kurt, 50 or 23% of American adults over the age of 50 don't have a trust. So what's the difference between will, trust? Do I have everything I need in the estate planning? Well, we're here to really help you. Some of the things that we have found of why people don't have an estate planning. Well, the first one is it's intimidating. Why would you even want to begin that daunting task of putting everything together? And did you forget something? The other is the attorney fees. The attorney fees, we'll touch upon this later in the presentation, but boy, those can add up. And then we're all nervous about updates, contacting the attorney. When do I contact it? When do I update my will and trust and my other important documents? The next one is it's uncomfortable. I will admit my husband was one of those that did not like to talk about this final days in my estate planning and what happens if I die. And really, the final one is it's too complicated. We hear it all the time. How do I know that I have all the documents in place, that what I need or what my family needs, so I'm protected, they're protected, and that we have everything ready to go? So people really ask us, do I need one? I really don't need one. I don't even have one. Well, actually, you do. Even if you do not have a formal estate planning in place, you actually have one. And Kurt, I'm going to have you join in here and help people understand what is it that they have if they don't have a formal plan from an attorney. What do they have?
Yeah, thanks, Jennifer. So, as Jennifer is alluding to, there really are two plans. You have a plan, whether you thought you did or not. You can set one up according to the way you want to do it, or you can do it according to the government's plan. You get to choose. I wanted to just share a little bit about how that works. Personally, we got to discover how the government plans work. My dad, when I was 16 years old, he was a runner, and he went out for a run one night like he always did, and he did not come home. And we were called by my uncle to let us know that there had been a runner who'd been out running and been hit by a car. And we rushed to the hospital and found out my dad had passed away. So we got introduced to the concept of having a will and power of attorney and documents put in place for us by the government. The government plan was not very friendly. Um, it put money in the hands of my stepmom, but only half of what she thought she was going to get. The other half was put into trusts for my sister and I, and neither of us were 18 yet, so the money just sat there and couldn't be used by anyone. And then when we turned 18, then all the money that we were supposed to get, which wasn't very much, was then given to us as 18-year-olds. And you can only imagine, I know what I did as an 18-year-old with the money. Probably not the kind of plan that you would want to have. So a lot of questions that we have is, the assets that you have and the healthcare and your family's future, what do you want to happen with that stuff? Do you want to choose it, or do you want the government to be able to choose it? And then the other part is the question we want to ask is, how much of your estate do you want to be given to the attorneys and the court system and the state? And we'll talk a little bit more about that as we go. If you pass away and you don't have any estate planning documents put in place, you get to do something called going through probate. So it means you don't have an official estate plan that you put together, so the state will come in and choose one for you. And it's a process that you have to go through. The court gets to decide then who gets your assets. All of your private matters that you wish could stay private don't get to be, they get to be public, get to share that with everybody. And then there's a time wait. Families have to wait quite a while in order they can get receive any of the assets that they get. It can be a process that you wouldn't enjoy. Trust me, I've been there. On average, it takes about 12 months to go through probate. It can happen a little faster than that, but there's usually a 6 to 9 month wait before probate can even begin. So you have to wait for creditors to get a chance to come after your assets. If you have assets in more than one state, maybe you have a cabin in the next state over, well, then you have to go through probate in every state that there were assets. So that just adds time, confusion, and cost. And literally thousands of dollars of fees and costs can be added up very quickly. All right. And ultimately, your heirs can get the estate, the assets in the estate, but it just takes time and effort. Now, we alluded to that there's costs. There's filing fees in every state. There are also, these can amount to hundreds of dollars. There are legal notice fees that you have to pay. There are bond fees. There are personal representative fees. There are attorney fees, which you alluded to. Those are not cheap. And then there can be appraisal fees. You'll have to go get values of all the assets. What are they really worth? Because they might want to give half to two different people. Well, what does half amount to? You have to do that. The average cost of probate can range anywhere from 1 to 10%. And that assumes that everything goes smoothly. What if family members begin to debate on whether or not the table, belongs to Joe, or does it belong to Sally? Well, Aunt Susie said Sally's supposed to get it. Well, that's not what Joe heard. Joe heard something different. So that can begin to add things up. So a very small estate of maybe just 300,000, which could include a home and maybe a small savings account and checking account, could amount to that. Can add up very quickly to 3,000 to 24,000, even more, depending on how complicated things can get. Under some state laws, attorneys and the personal representatives are also entitled to reasonable compensation, which means that even more of the estate can be paid out before it's ever given to the heirs. The average typical probate cost is around $2,000 to $5,000 just for the probate process, not all the extra fees. And again, we mentioned it can take 6 months to over a year just to allow time for things to be settled. And then again, loss of privacy in the process. So there are lots of benefits for avoiding probate. We've alluded to those. So saving money, everybody likes that part. We'd rather have us have the money or your heirs have the money rather than giving it to the state or the attorneys. Saving time. Why drag this out I've seen examples where people have this been drawn out for 3-4 years. Imagine if you were depending on that for your livelihood or for reaching new goals, if you have to keep waiting and keep paying attorneys through the process. Just think about all the stress and the paperwork that you have to go through in all this process. It can become overwhelming, especially at some of your most emotionally draining times, most challenging times of your life. And then again, we've alluded to the privacy. We just don't. Do you want people to know what you had in your assets? Do you want that to be public knowledge that anybody can go find out, or would you rather keep that to yourselves, to your family? A way to avoid probate is to do something called creating a revocable living trust. A revocable living trust or a living trust or revocable trust, a lot of different names, is really just a contract. It's a contract that sets up a separate entity that will live longer than you do. And it is something that tells your heirs what you want to happen without having to go and get permission from the probate court. So your assets can be titled, or a word we're going to use in the future is funding. We can fund your trust with assets, and then they will pass directly to the heirs based on the beneficiaries you set up in the trust. It's very, very important, right? So a revocable living trust, I started to talk about that. It's a legal document that creates a new entity. We fund assets. It means we transfer your assets into the trust. When you're alive, you get to own and control the trust, so you can actually move assets in and outside of the trust. So you can buy and sell assets. When you do pass away, then the trust is now again the owner of those, and the trustee of your trust, the manager of your trust, can come in and do what your trust says. While you're still alive, though, the trust being revocable means it can be changed, so you can change it. You can change what's in it, what's out of it. You can change the beneficiaries. You can change how things work in it. So you have all the control, which is important. All right. Remember, you get to decide with the trust, not the courts. So you get to decide who gets your hard-earned assets. You get to determine when they get your assets, so you don't have to get it all in lump sum like we did when I was a kid. It can be spread out over time. You can spread it out so they get it at different ages, which is very important. Maybe your kids aren't doing great and you want to wait till they're 65 before they get any of your assets. That's something you can do in your trust. Lots of options. You get to determine whether they get them spread out in chunks or whether maybe they just get income every year and that the assets remain. You can choose those kinds of things. If you become incapacitated, you get to determine who gets to make those decisions, and then who manages the assets on behalf of any minors, and also get to choose who gets to raise your children. Do you want the courts to determine who gets to raise your children, or would you like to have the ability to make that choice? So a comprehensive plan includes a number of different documents. It's the revocable living trust, which we've talked about, but it also includes things like the living will, it's called a living will and testament, or if you're using it with a trust, it can be called a pour-over will. There are the durable powers of attorney. Talk about that in a second. There are the advanced directives, advanced medical directives. And then we've also included a financial overview. We'll talk about that in a little bit. So a last will and testament is a document that when combined with your estate planning tools, specifically the trust, if you forget to put something in your trust, to assign it to your trust, the will do what's called pour over. It will pour those assets over into the trust even after you're gone. The hard part, though, is that those unfunded assets will have to go through probate first. So we want to make sure as much as possible that we're keeping you up to date on these things so that you're putting assets in the trust that need to be there. Okay. The power of attorney documents, there are two main kinds. There's one for finances and there is one for your health care. So if you become incapacitated, the question is, who gets to make choices on your financial decisions, or what do you want to happen with your health? The word durable just means that it's going to endure. It's going to go beyond you, even while you're incapacitated. And it gives somebody the power to make decisions on your behalf if you're not able to. Okay, so any assets that haven't been put in the trust, that are not funded in there, those are the assets the power of attorney has control over. Once the assets are funded in a trust, then the trustee of your trust will make those decisions. The power of attorney does have the ability to transfer things into the trust, and then the trustee could take over. Now, that could be the same person. or it could be different people. That's totally up to you. Okay. The power of attorney for healthcare allows somebody to make decisions on what you want to happen if you're in the hospital or if you are become terminally ill. Uh, do you want to be on life support? Do you not want to be on life support? Do you want to be resuscitated? Do you not want to be resuscitated? Do you want to be fed? Do you not want to be fed? Those kinds of things. It's important to have all that written down, because if you don't have it written down, once again, then they have to go before the court, and the court gets to make those decisions for you and on your behalf. It's been several years ago, many years ago now, there was a lady by the name of Terry Schiavo, which was a really big case. And Terry Schiavo was incapacitated. She couldn't speak. And her mom and dad came in and said, this is what she wants to have happen. But her ex-husband, who had a girlfriend, he said, no, Terry told me what she wanted, and she wanted to be terminated if she ever got in that position. And they had to go to court, and ultimately the ex-husband won out, and Terry Schiavo was allowed to basically pass away. A very, very sad story. But again, if you don't have it written down, then the government gets to decide what you want to happen. So the living will and the advanced directives, these again are tools on what you want to happen. If you're in a coma, or if you're terminally ill, what do you want to have happen? And then this gives the instructions to the doctors on what you want to happen, not what the doctors think or what anyone else even in your family thinks. Okay. So a question that comes up a lot is, well, I have a will. In fact, you can actually write a will on a napkin if you want. The challenge with having just a will is that it is just a wish document. Anything that goes through the will, if you just have the will, it will have to go through the probate court process. Again, we're trying to help you avoid that as much as possible. Having a will is important. It can also be contested, as we mentioned. So a will is just a nice document. It should be part of your plan, but it should be your only plan. So with that, I'm talking about the last will and testament, and that it's a tool that is really a wish document. I wanted to start to talk to you about the solution. So I'm going to hand it over to Lance, and Lance can get into talking about that. So here you go.
All right. Thank you very much, Kurt. We've talked a lot about estate planning, why many have not chosen to do estate planning, what happens if you don't do estate planning. And so really the question is, what's the solution? We find it to be very hard and cumbersome sometimes as well. So what's the solution? Well, we have a solution, and it's basically an internet-based estate planning technology software that can help you to do a complete estate planning program to make sure that you are personally put in the proper position to take care of yourself and your loved ones. And this is so very, very important, isn't it? And, we talked about the process of estate planning being cumbersome, having to maybe make an appointment with an attorney, and just the whole situation of not really wanting to do. But we make this process very simple to get very comprehensive estate planning done for you and your family. And as you can see on the screen there, you've got many different tabs of that process of getting a very comprehensive estate plan done, from the will to the trust to power of attorneys. All that process is done very easily and simply. Now, we're going into the platform a little bit more with this, but we can hear the constant theme that we make the process easy and simple. It's an online platform that walks you through the process of your estate planning. What's even better is you've got information and video links that you can watch that can help you understand the process of getting your estate plan documents done. And then we add another layer to help you out, and that's through our concierge program, where we have a concierge benefit where that individual walks you through the estate planning process. you think about it, it's very important to do. And when you have a process that makes it easy, it makes you want to be able to get that done so that you can take care of your family. Now, with this process, you have a 24/7 secure document vault that you can put your documents in. We know that life changes, that many things take place, and you want to be able to get to those documents easily and effectively, and you want to store them in a protected area. I know for myself and my family, we even have our um, our birth certificates stored away in this secure vault. We have our passports put in here as well. So it adds a huge value that you can put anything that you want to be secured, those documents in place, bank statements, what have you, as well as your estate planning. But you've got 24/7 access to this. So some other things that you can benefit from is, again, preparing that trust. Now, it can be cumbersome, but as you can see, we make it very simple. We give you a process. We ask for basic information to get this trust done. Your name, contact info, names and dates of births of yourself, your children. And it's, again, a step-by-step process that helps you to get this done, to make it easy, efficient, and so much so that this process can create documents in about an hour for you. And that saves a ton of time when you're trying to do something as important as your estate planning and your trust. You need something that's going to be very, very flexible. And I know just in my life of just a handful of years, I've had many different changes, take place. I've been married. I've got stepchildren. I recently lost my mother just last year. So when you're looking for something that's going to be very efficient, very flexible, this platform really helps out in that degree. And again, this is something that hits near and dear to me, of being able to get these things done efficiently and effectively. And we talk about special needs. Here's an area where it's super, super flexible, because many have special needs children, special needs adults, and within our platform, this is automatically put in there for all trusts. That if you have this particular situation, the language is there to create special needs subtrusts in all the trust document plans that we have for our clients. So how does this actually work? So again, we're able to see right into the system as you're putting in your information of maybe the individual that has special needs. As you put their name and their information down, really all you have to do is just click disabled, and the beneficiary will be included in the special needs subtrust. Simple as that. And so that, again, takes a lot of stress off that process to make sure that special needs child, that special needs adult is done properly, because caring for special needs is an important matter. And the successor trustee will make sure that the child is cared for, providing health, maintenance, education, and support. They live off the trust you set up. That's so very important, again, because if you don't have that set up properly, what can happen? Well, if you don't, you could possibly knock out your special needs child or adult from receiving government benefits. And you don't want that to happen. So again, you can see how our system has made it very seamless to be able to set that subtrust up properly so that that special needs individual does not miss out on their benefits. Because If they receive a lump sum, that can knock them out, but beneficiaries will never receive a lump sum utilizing this process. They will receive income only from the trust. So again, the government benefits will not be jeopardized. So a lot of thought and planning were put in place to make sure that special needs children, special needs individuals are taken care of. Now we're talking about setting things up proper and making sure funding is done properly as well. And I'm going to turn it back over to Kurt, and he's going to kind of explain a little bit more of the importance of funding that trust properly, because we can already see in this scenario properly setting up this estate planning for your special needs children or adults, make sure that they don't miss out on benefits. Let's see what happens when you properly fund your trust.
Yeah, thanks, Lance. So again, we alluded to earlier that funding your trust, it doesn't mean that you're necessarily writing a check to someone. You can always write us a check though if you want. But funding your trust is really about assigning assets by changing the title of assets. So things you can see in the picture, like your home, could be a boat, could be your toys, those kinds of things. You're actually going to change the title of those assets to the trust, where the trust is the owner. And amazingly, one of the statistics that we heard is that 80% of attorneys who draft these kind of documents don't bother to help you fund the trust. So you pay all this money to have these documents drafted for you, and then it's just an expensive piece of paper. It doesn't really have any value because you never assigned any assets to it. Therefore, the trustees don't have anything to manage. So it's really important to make sure that you are funding the trust correctly, and that's something that will be talked about through the concierge process that we have. So there are 3 meetings that you'll go through when you meet with the concierge agent on this. The first meeting is just kind of an introduction. The second meeting is typically where you're bringing all your documents. And then the third meeting is where you're actually walking through and figure out how to fund your trust, how to reassign the assets. So I think that's really, really important. It's included in what we're doing. You'll notice again, this continuation on the screen is that they're literally have thought of everything you can possibly do. So all the possible assets you might have. I don't know too many people that have intellectual property rights, but if you have those things, they will be included in your document. So it's very, very important to make sure that nothing gets forgotten. It's all written down and accounted for. So again, this online process is just an amazing tool that we get to use. Now, we've alluded to the costs of seeing an attorney, and we're actually being very conservative on this page, talking about all the costs of having an attorney draw up these documents. So normally we have some associates that are attorneys that charge as much as $2,500 just to put a trust. That does not include the wills and the power of attorney and the other living directives that are there. In reality, this cost, if you had all the documents that we're putting together in this package, can be anywhere from $4,000 to as much as $8,000 to have it all done. And then if you ever decide that you need to change it, and Lance shared about the changes he's had just in the last 5 years, well, you'd have to go back to the attorney and pay that cost again to have everything updated, because they don't give you a discount if they're only going to update it. They charge you the full amount. So you can see that these costs can add up a lot over a very short period of time. So with this concept, what we're able to offer it is at $1,995 as a one-time cost. And then for $29 annually, you have the ability to update any of the documents or all of the documents as many times as you want for the rest of your life. So that's a pretty substantial cost savings to have all of this stuff put together for you. You pay the cost up front. It's less than what you typically pay an attorney. And then for a very small ongoing fee, you can make changes anytime you would like. Now, we also have included in this not only the estate planning documents, but we also wanted to include a financial overview. We use a one-page model in order to talk to you about your overall financial picture. And the reason we feel that was important is because so many people are not on track for retirement. In fact, a study by Fidelity just a couple years ago said that more than half of Americans are not on track for retirement. Now, we actually try to teach our clients how to become financially independent or financially free as soon as possible, not just when you get to age 65 or 70. But we think that's really important to discuss with our clients. So those who decide to move forward with their estate planning documents, we'll offer that included in the package. It's important to think about those things because just as much as last year in 2022, the market was not friendly. In fact, a lot of people lost 10, 15, 20%, even 30%, 40% of their 401k, their 403b, their retirement accounts through their employer. And that can take a lot of time to recover. So most people still have not recovered yet from that. And here we are almost halfway through 2023. So those are things we want to be able to help you with. We've included that in the package. So here's just a kind of a very small sample of our one-page model called the LEAP model. It's colorful, it's organized, it's efficient. It helps us to help you understand what you have, how it's working, is it working together, and in order to help you understand what's happening with your finances. So again, we include that with the package. So $19.95 one-time cost includes the 5 most important estate planning documents: the wills, the power of attorney, the living wills, the advance directives, and the revocable living trust. All those documents. Plus, we've added in the financial overview. Think it's heck of a deal. Great opportunity for you to have peace of mind. What's happening with not only what will happen in the future when you're not here or if something bad happens, but also to help you plan for the good things of what we want to happen so you can have it all done in one place. So I'm going to hand it back over to Jennifer to wrap us up here. We'll go from there.
Yeah, thanks, Kurt. When we talk about, your financial situation and really having a comprehensive plan, I don't know of anything else that offers, all the different components, including, that financial overview. That's you're already in your financial documents. It's really a great time to really understand what does everything look like and how might you be able to, be assisted even further. So, when we talked at the very beginning, there's why people don't do it, the intimidating process. We've taken that away too. As Lance has shown, all the step-by-step, and with the concierge, meeting with the concierge, you have that ability to, take all of that negative feeling of putting together your estate plan, and make it easier. And so if you're interested or if you have more questions, take out your phone, scan the QR code, and the QR code will take you to set up a 15-minute conversation with myself. I can help answer some of the initial questions that you might have. I'll even set you up with getting an appointment with the concierge, so you can get started right away, and really, really help you take kind of the intimidation out of, what do I do next? And for those of you who might not have your camera handy or even know how to do it, I know my mom would have been like, I don't even know what that thing is on the screen. So we've got you covered there too. On the screen here, we have our toll-free number and or the email that you can email me at and set up an appointment and have a conversation. And we're going to follow up after this webinar with you as well. Since you signed up for it, we'll send you a packet of information along with how to get started, and we can really help you smooth into that hand holding into making it not so intimidating. So on behalf of Lance and Kurt, I really want to thank you for joining us today, and we really hope to see you soon and really help to take the intimidation out of getting your estate plan and helping your beneficiaries benefit from all the hard work that you've done so far. So make it a great day, and we'll talk to you soon.